Today, as the title suggests, we are going to be talking about 5 common mistakes people make when they enter into contractual agreements. Hello, Legal Chatters. Welcome back to Legal Chat JA. I am Kimberley Downer and I am an attorney at law in Jamaica. Now, every day, people all around the world are entering into contracts, whether it be employment contracts, lease agreements, contracts for services, building contracts, and the list goes on. Contracts are legally enforceable agreements between parties. So that means if one party does not do what was agreed, then the other party can go to court to legally enforce the contract or require that that party pays something called damages. Damages is a legal term which means monetary compensation for loss suffered. Sadly, a lot of people make mistakes when they're entering into contractual agreements, and so as a result, they end up in court. So today I want to tell you 5 common mistakes that people make when they enter into contractual agreements, and I hope you're not making those mistakes, and if you are, let's change that. Number 1, not reading the contract. It has happened all too often. Persons come into my office and they say, I trusted the man. He said sign here and I just signed here. I didn't read the agreement because we had discussed it, and they just went ahead and signed it. No, legal chatters, when you sign an agreement without reading it, you do so at the risk of agreeing to do something that you never intended to do. So, for example, you and a vendor discussed a purchase price for an item, and the vendor said that the purchase price would be $10,000. But then you sign a written agreement which says that the purchase price is $20,000. You could quarrel and say that the vendor is wicked, but then at the end of the day, the written agreement would trump the oral discussions. Therefore, if the matter goes to court, the judge would likely find that you would have to pay that $20,000 for that item. So, what we have to learn today is that we must read our contracts before we sign them. Number 2, not getting an attorney to review a contract. When you're entering into a contract, especially when it concerns money or things you cannot afford to lose, employ a lawyer to assist you with drafting the agreement. So many times people enter into agreements, for example, to pay millions of dollars, such as to purchase property or to build on land, and they draft up the agreement all by themselves, or sometimes no agreement is drafted. Then when a particular item is not included in the contract and they face trouble, that is when they come to an attorney. Legal chatters, it will be better and may work out cheaper if you employ an attorney to draft and review your contracts. I'm going to give you a little example. Johnny purchases a parcel of land and hears about a talented contractor who builds amazing houses. He speaks with the contractor and tells him exactly what he wants. The contractor states that he can do the job. So the contractor goes ahead and prepares the estimate of costs, and Johnny signs that estimate. Johnny doesn't pay him all of the money because the estimate says that he should pay 50% up front. So he goes ahead and pays that 50%. The contractor agrees to get to work, and then problems arise. The time was not agreed in which the contractor would complete the building. And then 2 weeks after paying the money, Johnny can't get through to the contractor. The contractor comes a month later and starts the job, but he's building something totally different than what was agreed. He starts to demand more money although the work is not even half completed. Johnny states that he's not paying him any more money because the job is not even half completed. And the contractor said he's not going to do any more work because he needs more money. Now, if Johnny had employed a lawyer, the lawyer would have perhaps inserted clauses that gave timelines in which certain things were to be done. So for example, when the foundation is to be laid, a certain amount of money is to be paid. When the roof is put on at a certain time, then a certain amount of money is to be paid. A lawyer may also insert a sketch drawing of what is to be built. In that way, when you ask a lawyer to assist in the drafting process, if the matter goes to court, a judge is able to see in black and white what the parties agreed upon. If a contract is not properly drafted, or not drafted at all, a judge would have to consider what the contract was. That is, what is it that was agreed between the parties? Then a judge would have to make a decision as to who is telling the truth and who is lying. And that, legal chatters, is a risk that you would take if you do not have an agreement properly drafted. So my advice, employ an attorney, especially when the agreement consists of a considerable sum of money. Number 3, ensure that when you get those template contracts, you fill in all the blanks. If there are blanks, it is important for you to fill it out because there are some people out there who will fill it in for you with something that you did not agree. And sometimes a section of a page is left blank. If that is the case, you can go ahead and strike it out. Use a pen and strike it out. You do this to make sure that no one inserts a clause into that empty section that you didn't agree to. Some people also sign at the bottom of each page or at the last words of each page. Nothing is wrong with that. You may do so as well. Number 4, not getting a copy of the agreement. Many persons enter into agreements and do not take a copy of the agreement. This is super important. You need a copy of the agreement so that you may be reminded of the rights and responsibilities of each party. So make sure that you have a copy of the fully executed agreement so that if a party does not do what he's required to do, then you can remind them of their obligations as per the contract. And also, if it is that you need to sue on the contract, you can take that contract to court with you and show it to the judge. Number 5, make sure you get a copy of the agreement that was signed not only by yourself but by the other party. You do not want to be stuck with an agreement that was signed only by yourself. It is possible that if you try to enforce the unsigned agreement in court, that the court may very well throw it out. But every situation is different and there's a possibility that the judge may find that an oral agreement existed, although the written contract was not signed. So do yourself a favor and ensure that the agreement is signed by all the parties to the contract. And you also want to make sure, if possible, that there are witnesses who witness the signature of each party to the contract. So legal chatters, that's it for this week's video. Don't forget to like, subscribe, and turn on the notification bell so that you don't miss an episode. Until next time, let's chat legal and let's keep legally informed. See you next time.